Welcome to James Madison's Montpelier. I'm Ryan Nobles of NBC 12 in Richmond, and we're continuing our discussion on the Bill of Rights with Peter Irons, who's the political science professor emeritus from UC San Diego and a graduate of Harvard Law, Tim Longo, the chief of police in Charlottesville and an attorney himself, and Stuart Harris, who hosts a weekly public radio show called Your Weekly Constitutional and is on the faculty at Appalachian Law School. There's two important clauses in the First Amendment that are really being tested in our modern age, and that's petition and assembly. And Stuart, why were these two clauses included in the First Amendment to begin with?
Well, partly for historical reasons. Under the king, really the only way to get your grievances before the king was to actually bring a petition to him. And that's probably more of a historical aspect to that, but it was actually some recent history at the time. Think of the Declaration of Independence. It was a petition to the king. Hey, king, things are going bad here. Here is a list of our grievances. Would you fix it for us? It didn't work out so well, but at least that's the right they were exercising. The assembly, of course, is very closely connected to the freedom of speech, because back in the day, just about the only way to talk to other people was to assemble with them. I mean, certainly there was the press and certainly there were letters, but the primary political organization was some sort of meeting of people together. So very fundamental, both of them, to the functioning of any government and certainly to the functioning of a representative democracy.
And we've seen how it's changed our culture many different times. Peter, perhaps the best example was the civil rights movement in the 50s and 60s. How did the ability provided in the First Amendment really change our society?
Well, you're right. This was a watershed period in American history, the civil rights movement. I'm very proud that I was part of that and took part in a lot of the demonstrations about it. And the interesting thing was that on several occasions when we were planning demonstrations, I was the liaison with the local police officers to make sure that we had agreement on where we could assemble, what kind of sound projection we could use, how many people could assemble, and that generally worked out. But there are also times, and we saw these, for example, the Democratic National Convention in 1968, where the assembly and the protests spilled over into the streets. And this has happened, of course, with the Occupy movement as well. So you get into these conflicts between law enforcement officers and people who want to protest. And you have to decide, what are the limits? Can you impose conditions on assembly to basically protect the rest of the public, and at the same time allow the protesters to express their messages? And it sometimes gets quite messy.
No one's dealt with that more than Chief Longo. You've had the Occupy movement has taken up residence in Charlottesville on a number of different occasions. How do you deal with this? How do you provide that opportunity for them to express their view according to the First Amendment while at the same time falling in the guidelines of your city code?
It's a tough job. In this particular case, as you may recall, our local governing body, the city council, basically gave this movement the right to occupy one of our parks 24 hours a day, 7 days a week, for more than a month. They gave them that right. My job was to make sure that that right was protected. My job was to make sure that their behavior did not escalate in such a way that it created a risk to public safety. My job was to make sure the lines of communication were open so that everyone understood the rules of engagement, particularly when that time limit was up and council said, now remove them from the park, and do so in such a way that is as peaceful as they've demonstrated over the past 30 or 40 some odd days. It's a very careful balance, and I think it's something that police agencies across America are dealing with, and in many cases struggling with, in part because they don't understand the Constitution and the protections afforded by the First Amendment as it relates to assembly.
And I have to be honest, as a member of the press, I'm a little confused by that. So if the First Amendment gives me the right to assemble, but then at the same time my local city council sets up a restriction from where I'm allowed to assemble, how have the courts dealt with that in the past? Does the city council have the right to say you're only allowed to assemble in this area?
Yes. Time, place, and manner restrictions are generally allowable under the First Amendment as long as they are content neutral. So in other words, the city council can establish rules. Public parks are only open between 8 and 5. Everybody has to leave in the evening because, for public safety reasons or to allow the park to be cleaned or something. That's perfectly okay as long as they're not targeting some group with which they disagree. And generally speaking, the courts will uphold that. So I think actually in most cases during this Occupy Wall Street movement across the nation, people like you, Chief, have actually exercised enormous restraint, and local governments have been extremely liberal in terms of allowing the people to stay, when I think that the law probably would have allowed them to remove the groups after giving them an adequate opportunity to say whatever it is they wanted to say.
But Peter, I mean, you were on the ground level of this during the civil rights movement. Isn't getting arrested maybe part of expressing your disappointment or your disagreement with the government that you're protesting against?
It actually is. I remember vividly the first time I was arrested in a civil rights demonstration. It actually took place in a bowling alley in Prince George's County, Maryland. Wound up in the Upper Marlboro jail for a night or two. But the point was, and here's where one of the differences is, a lot of those demonstrations, the civil rights demonstrations, took place on private property, inside restaurants, lunch counters, bus stations. So the law enforcement would say, we're upholding the right of private property owners to decide who should come on their property under what circumstances. Now the courts later, of course, by enacting the Civil Rights Act of 1964 in particular, made public accommodations open to all persons without regard to race or ethnicity or anything else. So in a sense, the boundaries of where assembly can take place and expression can take place have widened considerably since that time.
All right, very good. Thank you, gentlemen.